well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. I am so glad you're with me on the program today. Coming up, we're going to be talking with Cody Wisniewski from the Firearms Policy, well, actually the General Counsel and Vice President of Legal for the FPC Action Foundation. That is a mouthful. We're going to be talking about a lot of things, actually. The Rahimi case, which is, percolating at the Supreme Court. The Bruen response bills that we have seen in states across the country, including New Jersey, as well as, where Cody thinks we are right now. A little more than a year after Bruen. What changes hath Bruen wrought? We'll get to that here in just a moment. Before we do, however, Biden's America. It's crushing us. You've got companies laying off tens of thousands of workers, one after the other. Americans working two jobs just to get by. Inflation pushing hardworking families to the brink. Just look at the price of lunch meat next time you go to the grocery store. And the digital dollar could be coming down the pipeline to completely destroy our way of life. The truth is, you need a plan. You know it, and I know it. And that is why you should call Goldco. So you can diversify your savings and investments with gold and silver before things get worse. They're a 6-time Inc. 5000 winner, 2022 Company of the Year with thousands of 5-star reviews, and they've helped people like you and me place over $1 billion in gold and silver. They're offering up to $10,000 in free silver while supplies last. And if you call Goldco today, qualified callers will get a free Ronald Reagan half-ounce silver coin. So don't wait. Call 855-412-3806 today. That's Goldco at 855-412-3806. And now let's get right to our conversation with Cody Wisniewski of FPC's Action Foundation about the changing legal landscape when it comes to our right to keep and bear arms. Take a look and a listen. Cody, thanks so much for coming on the show today. It's great talking with you.
Yeah, thank you for having me. Happy to be here.
Absolutely. And I want to make sure that I get your title correct. So can you tell me what it is?
Yes. So I am General Counsel and Vice President of Legal at FPC Action Foundation.
Okay. Now, what is FPC Action Foundation relationship to the Firearms Policy Coalition?
Yeah, we work together on a lot of cases. So I'll represent FPC, which is, the membership organization, and I'll oversee the litigation portfolio. So I help FPC with all of the fun cases that people like to follow along.
And there are a lot of cases going on. Do you have any idea how many cases you were involved with at the moment? Can you even keep track?
Yeah, I do. Yeah, we have about 53 active cases across the country, and that's just like direct rep litigation cases. So those are everywhere from, California to New York, everywhere in between. And that doesn't include, the cases that we do amicus briefs in. That doesn't include our research portfolio and all of our other work.
Yeah, and the amicus briefs are important because, the next case that's coming up before the Supreme Court, U.S. versus Rahimi, this is not a case that FPC or any of the major organizations brought, right? This is a public defender who brought this case up to the Supreme Court.
Correct. Yeah, Rahimi has a federal defender, and that's the lead attorney on the case for Rahimi's defense.
Has FPC filed a brief in that case? Are you all planning on filing a brief?
So we're keeping a close eye on what's going on. So briefs, Rahimi's brief isn't due until late September, mid-September. And so any briefs that are filed in support of Rahimi will be filed after his brief is due. So we're keeping a close eye on it. It's a really, interesting case. It's one of those cases where the principle that underlies it and the ruling are going to matter, have potential to matter a lot. But there's, of course, like in any legal case, there's a fact pattern that can be read a certain way and can be used a certain way to try and get a broader win against the principle, which is what we're watching for closely.
Yeah, I mean, this is, I don't think anybody would say that Zacky Rahimi is the poster child for a Second Amendment case, but this issue isn't about Zacky Rahimi, right? This issue is ultimately, and that's what the government's going to try to make it about. This is a bad guy who shouldn't own guns, but the real question is whether a civil restraining order comports with the history, texture, and tradition test that was laid out in Bruen. Can you deprive somebody of their right to keep and bear arms based on nothing more than a civil restraining order? Is that how you all read this case?
Dead on. Yeah, you got it exactly right. The problem here is that the federal statute is incredibly expansive. So we've heard of these 922G cases, right? These are these cases that have been coming up that are dealing with, the so-called felon dispossession statute. It's not actually just targeted towards felons. The disarmament surrounding, drug use, and then also this lesser referred to provision, which is for a civil protection order. And then in the provision under 922 G8C2, which is the kind of super subsection of the subsection, it actually just allows people to be disarmed, not just under a civil protection order, but without any finding of them actually being dangerous. And when you look to the history, when you look to, that time surrounding ratification of the Second Amendment, it's clear that there weren't these broad disarmament statutes. They were very focused, and it was always focused on, or almost always focused on, dangerousness, setting aside, of course, the statutes that were blatantly racist and discriminatory, which obviously don't inform our understanding of constitutionally protected rights.
Yeah, and this is, it's funny because the government wants to use those statutes, right, to bolster their case, but they don't want to say, well, we're arguing that these racist laws were okay. Basically, they're taking the tact. It seems like, okay, yeah, these laws were unconstitutional, but the basis for those laws, ruling an entire class of people to be dangerous, well, that's just fine and dandy.
Yeah, several governments across the country have taken that position. The AG in California submitted an entire spreadsheet of all the laws that they were going to rely on in one of our cases. And in that spreadsheet, right, it's just chock full of these laws that disarmed slaves, freedmen, Native American, Indian tribes, and Catholics. Catholics were disarmed a lot at the founding. They were really worried about, the Catholics taking up arms and partnering up with the loyalists that still lived in, modern day Canada. But then at the end of the AG statement, he went and said, of course, these support our position, but we don't endorse the content or their discriminatory nature. And I don't know how you can rely on a law that disarms slaves to support your modern gun control agenda and then just ignore the fact that was specifically targeted at slavery. Like, it's astounding to me the jumps that they make. The only thing that I can take away from that is that essentially, California views most of the people that live there as slaves to the state. And I'm not really sure what else we're supposed to draw from it. But yeah, they point to these blatantly discriminatory laws to try and justify their modern gun control efforts when they don't actually have any analogous, link to this modern day gun control. And we as a country have amended the Constitution since that point and have fully prohibited anything like those laws from coming into place again.
Absolutely. I mean, I think that, my attitude is, as this country has progressed, we have continually strived imperfectly to become that more perfect union, right? So who we the people is today is not who we the people might have been back in 1791, but the rights that we the people possess haven't changed, right? Who gets to exercise those rights has broadened, and I think that's a very good thing. But the rights themselves are fundamentally the same that they were in 1791. The gun control advocates and the Biden administration argue that, in essence, that right was so limited to begin with that it can be regulated into non-entity at this point.
Yeah, and that's what's so important when you're talking about the Rahimi case and other cases is there's an underlying natural right here, a natural right that pre-exists the government, pre-existed the Second Amendment. And every human being has that natural right. The question here is, does the government have the power to stop Rahimi from exercising that natural right based solely on a civil protection order? Now, there are a lot of other things in Rahimi's past and in the fact pattern that would probably, weigh in a different favor. But what's clear here is just the facts specifically of this subsection. And I think a lot is going to get lost in this case. It's going to be one of those cases where all you're going to hear about is, Rahimi's past and Rahimi's actions that aren't at issue in the case. And the fact is, it's the underlying principle that really matters. And so we have to be able to peel away those layers and look at that underlying principle and look at not just how this is going to impact Rahimi, but instead how this case will impact, the tens of thousands, hundreds of thousands of other people around the country who, might be might be otherwise deprived of their rights, that they're not, that there's no historical justification to do so.
Absolutely. And in the case of Zaki Rahimi, again, I mean, there are allegations of violence, long before and after this civil restraining order was issued. But then you have a case like Range versus Garland, right, out of the Third Circuit. And this is a case where a guy wasn't even convicted of a felony offense. It was a misdemeanor that was punishable by more than a year in prison in Pennsylvania at the time. But it was basically, he was accused of falsifying his income on an application for food stamps. And here we are decades later, and Brian Range still cannot lawfully own a firearm. Now, this is another case that the Supreme Court could take up this fall. Is that right?
Yeah, it could. So it is on petition to the Supreme Court right now. And so they'll meet and review and decide whether or not they're going to hear argument in that case. And you're exactly right. And that's the problem with, if you focus too much in on just the Rahimi case, you lose the forest for the trees. You're talking right there about 922G1, right? And so that federally deprives anybody who is convicted of a crime that's punishable by more than 1 year's imprisonment from possessing a firearm for life. Now, you don't have to spend more than 1 year in prison, and it certainly doesn't have to be a felony. So if you're convicted of a misdemeanor that's punishable by a year and a day, and you never set foot in a prison or in a jail, you are still disarmed under that statute. And it applies to people like Range, where I think it was yard work on the side was the income that he wasn't disclosing. It applies to people, we've seen cases before. There was a gentleman who was importing illegal cassette tapes in 1987, who is forever prohibited from possessing a firearm. There was a woman who, lied on her tax return, and the court said that she deprived the government of the property it was due in order to justify upholding the law. So these are the kinds of people that are being disarmed under these statutes. It's not just targeted at actual dangerous people like it should be. It's focused, and it's so broad that it just grabs all of these people who, might have made forgot to disclose their lawn care income on a federal application, and thus have deprived the government of property it was due in the case of taxes, according to the court. So it's just offensively broad.
Absolutely. The idea that a bootleg Whitesnake cassette would deprive you of keeping and bearing arms forevermore is ridiculous. But, I think it's beneficial for the government to have Rahimi come first, right? Because they can make this case that, this guy's such a dangerous person, this law has to be upheld, without necessarily having to get into how this law is so broadly applied to people who clearly have exhibited no signs of dangerousness. Do you have any concerns about how these cases are stacking up at the Supreme Court, as well as the move by the Supreme Court to, not get involved in these early emergency appeals in places like New York and Illinois?
Yeah, I mean, this is kind of common if you ever follow the court. I think what's really new about it is it's kind of new for us in the Second Amendment space and in the gun space, right? We've had the opposite, that we've just kind of seen the court broadly ignore the issue for a long period of time, right? Between Heller and New York State Rifle and Pistol Association v. Bruen, right? You only really had two things go up. You had Caetano in 2016, which was that per curiam opinion about stun guns. Mm-hmm. And then you had New York State Rifle and Pistol Association v. City of New York, which was the case that was granted before Bruen, that New York, sprinted and changed their law so that they could moot out the case. So, we were more used to the court just kind of not weighing in on the issue. And so now that there are so many things going up, and that it seems like the court is more willing, at least, to take on these issues, it's going to be interesting to see what happens over the next couple of years. But for people who don't generally follow the Supreme Court, I mean, the Supreme Court is basically the only court in the country that gets to choose the cases it hears. And it takes less than 1% of cases that are presented to it. So, there will be thousands of cases that will be petitioned to the court, and they're going to hear about 60 to 70 in a term. So it's incredible. It's very common to have cases go up and just nothing happen. The difference that we're seeing now is that these lower courts and these circuit courts under Bruen are striking down gun control laws. And they're striking down not just state gun control laws, but they're striking down federal gun control laws as well. And when that happens, the Supreme Court gets a lot more interested. And of course, the United States has to then be the party that's asking the Supreme Court for review. And when the United States is asking, it's also more likely that the court grants review. So you've got this Rahimi case where Rahimi won at the Fifth Circuit. So the United States petition. You've got the bump stock cases, right? You've got Cargill, our cases, Gades, and you've got Hardin that are all on petition at the Supreme Court. Well, the government lost in 2 of those. And so now the government is the one that is asking the Supreme Court to review. And then, of course, we had our Vanderstock case, the case about the ATF's framer receiver rule, go up to the Supreme Court. And unfortunately, they granted a stay of the effect of the decision. But, the substance of the decision, the reasoning remains in place. And we're going to be arguing that at the Fifth Circuit. And, there's another potential where, when we defend our win at the Fifth Circuit, that the government will be, could be in a position again to be the appealing party. So it's not uncommon, but we're seeing a shift that I think is really going to change the way that the Supreme Court weighs in on these Second Amendment cases.
I mean, I hope so, because we also are, you talk about the laws that are being struck down, but we've also seen, I think, some abuses of the Bruen decision to uphold some laws, right? Where you have a federal judge declare that, well, magazines aren't arms. They're not protected by the Second Amendment. Or, AR-15s, modern sporting rifles, the most commonly sold rifle in the country, are unusually dangerous. And so therefore, they're not protected by the Second Amendment. The hopes that Bruen would sort of, smack down these activist judges, clearly that's not the case. But do you think that it's become harder for these judges to try to justify these decisions because of the Bruen test?
Absolutely. Well, 2 things. One, we've seen, significantly more victories after Bruen than we saw after Heller. More in 1 year post Bruen than after Heller, because courts, Bruen really just told the lower courts, hey, you know what we said in Heller? We really mean it. That's what we really want you to be doing. And so I think that reiteration kind of helped in a lot of different courts, at least. The other side is, yes, we're seeing bad history, right? We're seeing judges point to, statutes that are analogous, statutes that shouldn't be informing the analysis. But what's important is they have to tangle with the history, right? We've stepped into a new era where Second Amendment litigation is in the realm of originalism, right? The original public meaning of the Constitution, the original public meaning of the Second Amendment, what those words meant when they were drafted and ratified in 1791. So even the courts that are coming out and are making bad analogies and are upholding, some of these laws that should be struck down as unconstitutional, they're forced to tangle with the history. They're forced to do originalism, and they're forced to put their cards on the table. When you were dealing with, these social science data points and this balancing of rights, they could kind of just lose the right in the mush of social studies. And now they're forced to actually, do originalism. And I think it's bringing a lot of things to light. It's making a lot of people aware of these, the statutes, the kind of statutes that the government is relying on for support. But it's also a step in the right direction. We're moving more and more to a place where we're having the right conversation. So it's easy to get disheartened when you see, orders come out of certain courts that are just so obviously bad. But I think, what we'd like to convey, or what I'd like to, hope that people can take away, is that, we are trending in the right direction. There are good things happening. We are getting injunctions. We're striking down laws. We're tallying up wins. We're beating the Biden. Every, federal ATF rule that has been published in the last 10 years, right? The bump stock rule, the framer receiver rule, and the pistol brace rule have all been in some way either struck down or enjoined. And that's massive. Yeah. So there are a lot of wins, and it is important that we're talking about history.
Absolutely. And, and listen, I mean, speaking of history, you're right that these things don't change overnight. And I think that this is the civil rights fight of our time. I live in Central Virginia, outside of a little town called Farmville, which Oliver Anthony made famous a couple of weeks ago. But, that town was actually the bulk of the cases in what became Brown versus Board of Education. It was kind of rolled into the Topeka cases. And after Brown versus Board of Education came down, Prince Edward County, Virginia shut down the public schools for 5 years rather than integrate. It took another Supreme Court case in 1965 before the schools reopened. So, these things don't happen overnight. Change is not as rapid as we would like to see when it comes to, recognizing our fundamental right to keep and bear arms. But I think that you're right that we are trending in the right direction. And I think a decade from now, we're going to have a very, very different legal landscape than what we have today. And we're going to have a lot more support in the courts for our right to keep and bear arms. Do you agree?
Oh, absolutely. I mean, you can see it. Look at concealed carry. So look at a map of what concealed carry laws were like in the 1980s, right? Just about every state in the country outright banned it. Some states had some super restrictive permitting processes, but it was really difficult to be able to conceal carry in the 1980s. And now today, we've got 27 states that are free carry states where you can, as a matter of your right, carry a firearm in the manner that you see fit, so long as you're not a prohibited person. I mean, that's a huge shift over just 40 years. And that's what we're seeing. And, something you said is really important, right? It's a process. Right. Our rights weren't restricted in this way in one fell swoop. Right. They didn't pass one broad overarching gun control statute that stripped everybody of all of these individual facets of their right. It was done incrementally. And, what we're seeing is those things fall statute by statute, subsection by subsection. And that's really important. You're not necessarily going to walk in and strike down the biggest gun control statute tomorrow, but you can strike down all of these individual provisions in all of these different cases and start getting to the point where people's rights are actually being respected and hopefully to a place where they're actually being protected.
All right. Now, listen, we're running out of time. I can keep you all day, but I know you got a lot of work to do here. So I'm going to ask you, of all of the Bruen response bills that you've seen, and a lot of them are very, very similar. What do you have one state in particular that you think has gone more overboard than the others in terms of lashing out at gun owners and the Supreme Court?
Yeah, so we are currently engaged against New Jersey's Bruen response bill, and we just filed a brief in that case not that long ago, and that one is particularly offensive. Any state that is deciding to just basically work around Bruen and try and stop people from being able to carry in public, ranks pretty high on my offensive list. But New Jersey's is pretty bad. I mean, it really restricts what people can do and makes it to, basically is like, yeah, sure, you can have your permit, but you can't go anywhere with your firearm. So it's this kind of roundabout, insidious way of making everywhere a sensitive place.
Yep. Yeah, absolutely. We saw that in Montgomery County, Maryland, too. I looked at the map of the gun-free zones. And then the map of the population, where people live in Montgomery County. And man, it's almost identical, right? Anywhere people live, that's where your second rights are denied. All right. Yeah. Well, I got one more follow-up for you. One quick one. How many times during the writing of an average brief do you have to stop yourself from typing F you know and then hitting send?
I think that's privileged information.
Hey, Cody, listen, man, thanks so much for everything you do. I really appreciate you coming on the program. I would love to have you back whenever you can carve out a few minutes, but really appreciate you joining us today.
Absolutely. Thanks for having me. Pleasure to be on. Thanks for letting me talk about our work and the cases. And, hopefully everybody can follow along and watch some more victories.
Absolutely. Cody Wisniewski joining us from FPC Action
Foundation.
There you go. Right here on Bearing Arms Cam and Company. Appreciate Cody joining us on the program. And now let's get to today's Armed Citizen story, our good deed of the day, and our recidivist report. We've actually got a twofer. Yes, our Armed Citizen story is also our recidivist report with a headline from the website CWB Chicago. Armed carjacker got shot by concealed carry holder while on probation for a carjacking case. Yes. I'd say only in Chicago, but I don't think so. Actually, that probably can happen in a lot of major cities. And until a few years ago, this would have been impossible in Chicago because Illinois had no concealed carry law. That has changed, and now tens of thousands of Cook County residents do possess a concealed carry license and are protecting themselves, although in this case, the rideshare driver probably lost his job as a result of acting in self-defense. 20-year-old Derek Benson held without bail by Judge Charles Beach, according to CWB Chicago, on a fresh charge of discharging a firearm during an aggravated vehicular hijacking, as well as discharging a firearm during an armed robbery. The rideshare driver allegedly picked up Benson and a juvenile female back on August 12th, shortly after midnight. Benson allegedly pulled out a gun, pointed it at the driver's head while sitting in the back seat, as the juvenile female, also in the back seat, patted down his right pants pocket. Assistant State's Attorney John Kyle said during Benson's bail hearing that the driver, a 26-year-old concealed carry holder, slowed down his SUV, then jumped out while it was still moving. He ran a short distance, pulled a gun from his left pants pocket, and fired 3 shots at his car. Benson returned fire, tried to get into the driver's seat of the vehicle, but the SUV wouldn't operate because the key fob was out of range in the driver's pocket. Benson and the girl then ran from the SUV as a passing motorist called 911. Chicago police were already on their way, according to CWB Chicago, because the gunfire had triggered a shot spotter. Officers found 2 phones in the SUV, but the driver's phone, which he left behind when he bailed out, was gone. Yeah, that's right. The thieves left theirs, but took the driver's. The cops found the girl about a block away with a graze wound to her right arm. One of the phones in the SUV was hers, according to the prosecutor. The victim's phone was found on the same block. Benson, meanwhile, found in the entrance of an apartment with a firearm about 3 feet away. Police said Benson received a gunshot wound to his leg. Now, prosecutors also said that Benson is currently on probation for possessing a stolen motor vehicle after he was found driving a woman's Jeep after it had been carjacked in August of 2021. Prosecutors had initially charged Benson with vehicular hijacking, but in that case, they agreed to let him plead down to a lesser charge of possessing a stolen motor vehicle in December in exchange for the probationary sentence. Benson, according to CBB Chicago, also adjudicated delinquent as a juvenile for robbery the year before in 2020, and once again now facing some serious charges. Judge Beach noted that Benson was shot, which he says is, quote, tangential evidence of his proximity and time to that offense. So the fact that you could not comply with the terms of your probation tells me that you probably cannot comply with the terms of bail. Accordingly, you will be held without bail. We'll see how long that lasts. As for the rideshare driver, again, both Uber and Lyft have policies requiring that both drivers and passengers be disarmed, a prohibition, by the way, that Benson allegedly ignored. The driver apparently ignored as well, and likely, again, looking for new work, because we've seen this time and time again. Even when folks act in self-defense, if they're behind the wheel while they're driving for Uber or Lyft, they're tossed. Now, today's good deed of the day, from Nebraska, where a man saved a child from a drowning in Fremont County at the Waubonsee State Park. This happened just a couple of days ago. The young child, apparently autistic, had wandered away from his family. And Terry Travis, who's an employee of the Fremont County Secondary Roads Department, was driving through the park when he saw this child, 5 years old, standing on the dock at the pond at Waubonsee Park. He was by himself, and that's when Terry Travis saw the child actually jump into the water. He immediately took action. He left his vehicle, ran towards the pond. He could hear the child screaming, saw the child go under the water. Thankfully, Travis was able to reach in from the dock, grab the kid, pull him up to safety. The family arrived on scene just a short time later. He was checked by Sydney Rescue at the scene, transported by private vehicle to a Nebraska hospital for evaluation, but it looks like everything's okay. Thankfully, again, because of the quick thinking and fast actions of Terry Travis, in the right place at the right time, most importantly, willing and able to do the right thing. So, Terry Travis, thank you for your very good deed. Now, that is all the time we've got for you on this edition of Bearing Arms Cam and Company, but I want to thank you for being a part of the program as always. I'm looking forward to being back with you again tomorrow. Don't forget, by the way, Wednesdays, it's VIP Gold Live Chat Day. Hot Air's Ed Morrissey and I will be kicking around the day's top stories at 1:30 Eastern. You can be a part of it. I'd love for you to be a part of the conversation. All you have to do, go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. As our way of saying thanks for showing your support, we're going to give you exclusive content, news stories, and analysis, as well as things like this very fun VIP Gold Live Chat, my favorite hour of the work week. And again, just go to BarianArms.com/subscribe. You can find out more information there. We'll see you back here tomorrow. Until then, be well, be safe, and be free.